All right. So this is just We the People News. Gonna finish up on that one video with Steve Leto on property taxes because I actually think it's pretty important to know this. This tax law crap is ridiculous.
Nice place.
Thanks. Been renting 5 years.
Courts of common law, i.e. no money damages. The Court of Chancery soon interposed to assuage the harshness of enforcement of mortgages in courts of law. In equity, courts looked through the form of a contract to its substance. And by 1625, the Court of Chancery saw that while a mortgage agreement took the form of a conveyance in fee simple, it was in substance a security. A security was merely personal property, leaving the mortgagor with an equitable interest in the land. To vindicate that interest, the Court of Chancery recognized the mortgagor's equity of redemption, which allowed him to regain title to the land by repayment of the amount due even after the law day. In 1678, Lord Hale called the mortgagor's interest a title in equity. Okay? The court further observed that the interest of the land, meaning the interest in real estate or property, must be somewhere, cannot be in abeyance, but it is not in the mortgagee, the lender, and therefore must remain in the mortgagor, the landowner. Thus the courts conceived the mortgagee's right as a right to money rather than land. By 1759, Lord Mansfield, among English jurists, exceeded in eminence perhaps only by Coke and Hale, would say that the mortgagor's equity of redemption is the fee simple in the land. Hence, the mortgagor's equity to redeem had itself become a right of property. The mortgagor had an equitable stake in the land, and subject to legal rights of the mortgagee, was in equity regarded as its owner, and this equitable estate, which, following Hale, the courts would later call equitable title, could be devised or conveyed like any other interest in property. Yet, the Court of Chancery also recognized, at least nominally, the lender's right to foreclose upon the land. At some point after the law day, when the lender thought he had waited long enough without payment of the amount due, the lender could petition the court for a decree providing that the landowner do from this point stand absolutely debarred and foreclosed of and from all right, title, interest, and equity of redemption of and in and to the said mortgage premises. And the process was known as strict foreclosure, since it would extinguish the landowner's equitable interest in the property and grant the lender full ownership of the land, whose value might far exceed the amount of the unpaid debt. So people figured this out a while back. The English courts resisted strict foreclosure for the same reasons they recognized the landowner's equity of redemption. Indeed, the Court of Chancery would refuse to enforce even a landowner's separate agreement not to assert a right of redemption later. As the court said, once a mortgage, always a mortgage, meaning that as a practical matter, the lender could not convert a security interest as mortgagee into a fee simple title to the land. And even when the Court of Chancery granted a decree of strict foreclosure, it remained open to vacatur years later if the landowner filed a petition to that effect. Thus, in English courts of equity, the lender's right to foreclose upon the land was nearly always honored in the breach. As Joseph Story put it later, the courts of equity constantly allow a redemption, although there is a forfeiture. So by the end of the 18th century, American courts of equity had begun to address these issues for themselves. The American courts were uniformly hostile to strict foreclosure in cases like this one, where the land's value exceeded the amount of the debt. New York's highest court in equity, for example, opined that in cases where the mortgage premises exceed the amount of the debt in value, strict foreclosure would be unconscionable. Joseph Story likewise recognized the unconscionableness of taking the land for the money. In other cases, the court opined that strict foreclosure had no appropriate place in a system of laws and jurisprudence where the mortgage does not operate as a conveyance of the legal title, but is only a lien upon the land as a security for a debt or other obligation of the mortgagor. So they're pointing out, nutshell this for you, that back to the 12th century, the idea that you could put land up as collateral on a loan was recognized and enforced by the courts. somewhere along, somebody said, well, if they don't pay, I get to take the land back, right? And somebody said, well, obviously that's why the land is put up as collateral. Okay. And somebody else later said, well, it seems that if the amount owed is enough to cause a breach, but not enough to cover the value of the land, there's something wrong with that. And by the time these laws are being interpreted in America, for instance, in New York in 1827, the courts had recognized that there could be something unconscionable about it, taking the land that's worth substantially more than the amount that caused the breach. So the American courts recognized a creditor's right to have the full effect of his securities. That full effect, however, did not entitle the creditor to recover more than the amount owed. And believe it or not, the court now cites the Magna Carta. Magna Carta itself had provided that a debtor's lands could be taken only to the extent necessary to satisfy the debt. And by the way, they're not saying because it's the Magna Carta we must follow it. They're simply pointing out that there is a long, long history to this. Because the Magna Carta goes back to, I believe, 1215 or something. Yeah, 1215. And that's a long time ago. 1215. So this idea goes back at least that far. The innovation of foreclosure by sale exemplified the ability of courts of equity to craft an appropriate remedy where courts of law could not. And that, again, is why you're in equity, because you're not simply asking for money, you're asking for the court to allow you to foreclose on the property to recover your money. The New York court, in the case we talked about as a matter of judicial power and equity, said that the court may, when equity requires it, interpose at the instance of the mortgagor to direct a sale when the estate is greater value than the debt in order to prevent a strict foreclosure in the case. So that's what they talk about for quite a length of time. And then they point out Michigan law flatly contravened all of these long settled principles going back to the Magna Carta and earlier, when it allowed Oakland County to take absolute title to plaintiffs' homes as payment for their tax delinquencies. By taking absolute title to plaintiffs' property, the county took their equitable titles, and the county did so without a public foreclosure sale, without payment to the plaintiffs for the value of those titles. And so they basically point out that Michigan passed a law, and other states have done this too. Michigan passed a law, though, and said that we get to do this because we just said so. And strangely, like I said before, all of the government officials who are involved in these cases have defended them by saying, well, when you let your house go into foreclosure, you abandoned it. And yet when people get foreclosed on by the banks, they're not deemed to have abandoned their properties. So in sum, the takings clause is addressed to every sort of interest the citizen may possess. The plaintiff's equitable title to their homes with such interest on the facts alleged here, the county took the plaintiff's property without just compensation, in violation of the takings clause. Therefore, we reverse the district court's dismissal of the plaintiff's takings claim under the U.S. Constitution against Oakland County and remand for proceedings consistent with this opinion. The district court's judgment, otherwise affirmed as the plaintiffs Hall, the Lees, and Govan, won't get into that heavily here, meaning that I'm not going to talk about it at all. This opinion was just filed recently, and so it is hot off the presses, as they say. And I remember doing stories about this and being absolutely blown away at the idea that your house goes into tax foreclosure and they foreclose on it. They pay themselves for the taxes that you owed, and then they keep the rest. They just pocket the leftover money. And I remember when I first heard about this, an attorney friend of mine contacted me and said, hey, Steve, have you heard about this? I said, no. He said, I'm filing a class action on behalf of everyone it's happened to. I said, oh, good luck with that. And so I followed that story as it's gone through the courts, and it's something that he devoted a ton of work on. And I know that it ended badly in the state court system. The Michigan Supreme Court had said, no, it's one of our laws, and looks good to us. And so this is one of the reasons federal courts exist, is that if you have a problem that can be framed as a constitutional issue, you can often bring the claim in federal court. And so these people here brought their action in federal court. And in federal court, they said it's obviously a takings clause issue. Under the Fifth Amendment, you can't take property unless, due compensation, et cetera, et cetera. And so it seems that way, pretty obvious to everyone, but somehow the Michigan courts didn't recognize it. And the first district court, the district court in the federal system, didn't recognize it either. I merely mean first in the series, and the fact that they were the first ones to hear it. So they threw the case out, failure to state a claim. And the Sixth Circuit on appeal said, no, they stated a claim. And by the way, just in case you didn't catch it, the court didn't just say, we're going to reverse this. They said we're going to reverse this because of the fact that the case law going back about 900 years backs the plaintiffs on this. And the fact that everyone else seems to have missed the 900 years of jurisprudence going the other way, the court wrote an 18-page opinion, or thereabouts. So it can get thick reading at some points, but I like the fact that they call back to all those things from so long ago to point out that you have an understanding of what property is. When that understanding is enshrined in the Constitution, a state can't just come along and say, well, property means this, but not that. Yeah, it's not how it works. So this is a great case. The Pacific Legal Foundation was heavily involved in this, as were a whole host of other attorneys. And one of the reasons that there's 3 or 4 pages of introductory matter in the case caption is it lists all of the attorneys who were involved. And there were a lot of attorneys involved on both sides. And sadly, the county and the state of Michigan were fighting this because they thought that law made complete sense. That you could owe a couple bucks on your house gets foreclosed on, and they get to keep everything. Everything. So it was a crazy situation. Now we'll see what happens because theoretically, powers that be could appeal this to the U.S. Supreme Court where they would lose. I'm certain they would lose. But they probably won't get it taken up by the Supreme Court if they did appeal it. But now we're faced with a situation where all of the people who had this happen to them in Michigan presumably can now file lawsuits to get their money back. And the question simply becomes, how long ago did it happen? And is there a statute of limitations problem on that? So that's another story for another day. This video is run way over length, and I apologize because people complain on a daily basis that my videos are too long. And the only way you'd know that I just said that is because you're here watching me say it. So some of you stuck around. I appreciate that, but this is a huge, huge case. So I have to thank again Kate, the media director of Pacific Legal, for sending this over to me. Thank you very much. Pacific Legal does great work, just like the Institute for Justice. And they got this spun around at the Court of Appeals, Sixth Circuit, the federal system. And think about this. There are plaintiffs whose homes were taken, who filed lawsuits in state court and lost. Court of Appeals, state court, and lost. Michigan Supreme Court, and lost. District Court, and lost. Sixth Circuit Court of Appeals, and won. That's an extremely long road to travel to get what you're entitled to. But they won. And sometimes it's a long, long road to get there, but when you get there, the right thing happens. So there you go. Again, that's the case of Hall versus Meisner. It is huge news in Michigan. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Alrighty. So, in my opinion, okay, even if it goes to the Supreme Courts, if they actually sides on the county's behalf, right, there's going to be 3 things that attorneys is going to miss, and they will not do. 1 is challenging the word resident, okay, which American jurisprudence means renter. Number 2, they're not going to challenge the word ordinance, which means member of corporation. Okay, so the county is under assumptions and presumptions that you don't rebuke that you are a corporation. You must rebuke that, people. Okay, so that's 2. Number 3, and this is going to be one of the most important parts, is that they're not going to challenge the word person. Okay, everybody's going to go in there as a person, not a man and woman. Okay, persons have privileges, men and women have rights, and they have inalienable rights. But you change your rights into a privilege as soon as you become a person. So, resident, ordinance, and persons. You never challenge them three. That's assumptions and presumptions that you've waived your rights and you are a person. Alright? Remember this, y'all, more than anything else. Is a person male or female? Persons don't have sex. That's the reason why it goes to both genders, because does not have a particular sex. So it's never been really defined. Other than that, it cannot have sex because it's a corporation. So therefore, you're assuming that he is a good person. Well, a person is not a he. So therefore, he cannot be a good person. Just saying. He could be a good man, but he cannot be a good person. She could be a good woman, but she cannot be a good person. Just saying. Unless you're on paperwork. These will be the People News. By the way, most of these things do get settled outside these courts because the counties don't want the higher Supreme Courts to take the chance of the actually high Supreme Courts be more for the people than they are for the government. So they settle more than anything else and don't want to fight it. Now this particular is pretty rare. I mean, they pushed it and pushed it and pushed it. And again, the Supreme Court is going to operate with what the argument is, and nobody's going to argue with ordinance, resident, or person. So therefore, the Supreme Court may go ahead and go with the corporation side, which is the county, then the people side, which is the person. Because you only have privileges. Just saying. These will be the People News. Bye, y'all.